Good afternoon. I am Brianna Bogan, Director of Legal Services again, back at you. I will be moderating the judges' discussion today. I have the pleasure of introducing the esteemed Berkeley County Probate Judge, Honorable Keith Kornahrens. And Judge Kornahrens was admitted to the South Carolina Bar in November 1975. He began the private practice of law in North Charleston in the same year. He served as municipal judge for the city of Hanahan from 1990 through 1994. And he is also a former member of the Charleston County Board of Variances. So I would like everyone to welcome Judge Kornahrens.
Thank you for that introduction.
And to start off our discussion, could you please discuss what is the role and function of the probate court?
Thank you. The role and function of the probate court, basically we have four distinct areas that the probate court deals with. The first and easiest to understand is we issue marriage licenses. We do not do divorces. We merely let you get joined together, and after that you can go across the hall and get your divorce. So we have the easy part of that. Probably the part of probate court that the least people really understand would be our mental health or therapeutic division, which involves persons who have a mental illness and or a drug addiction. And we are involved in maintaining some semblance of order in their life and trying to ensure that they get the medical treatment that they need. I could talk about mental health probably for a couple of days, but it's a growing area of our office, a growing area of our society, and thankfully it's getting a lot more awareness as things have happened in the last couple of years. It seems COVID had a lot to do with mental illness being recognized and dealt with. The third area that we deal with is guardians and conservators. And guardians and conservators are persons who are appointed to take care of a person who, as a result of mental incapacity, is unable to take care of themselves. The guardian is in charge of the person. That means they make decisions for the person regarding their health, education, welfare, where they live, what they do. The conservator is in charge of the assets or income of the mentally incapacitated person. And at first you might think, well, they don't have any assets if they're mentally incompetent, but most people start off mentally incompetent, and then when they get about my age, they become mentally incompetent. And so somebody has to take care of our money because we can't do such a good job anymore. I hadn't had anybody appointed over me yet, but I guess it's coming. And the last area, and the area that most people think about when they hear probate court is, of course, probate. And that's the main focus of why we're here today. Probate is the name for a process by which a person who has passed away has their assets transferred to the persons entitled to those properties upon their death. And I understand you had some estate planning before me today, and so I don't want to go too much into that, but basically when someone dies, their property has to be transferred from themselves to someone else. And that takes place either by way of your will, if you have one. And if you do, congratulations, you're in the minority. But we hope that it will one day be the majority. And if you don't have a will, you do have a will. And your will was written by the state of South Carolina, and we call it the statute of intestacy, which says your property will go according to the way our legislature wants it to go. I was thinking about our intestacy statute, and I don't want to get too deep into bushes, but our intestacy statute says if you die without a will, this is your will. Half of your property goes to your spouse, the other half goes to your children in equal shares. I don't know why they decided that's what you wanted to do with your property. But I've had the privilege of being the probate judge for 20 years. We open about 1,000 cases per year. Of the people who have a written will, I have never seen one that said half to my spouse and half to my children. I have never seen a person who took the time to tell us what they wanted to do with their property to do it the way the state of South Carolina did it. Why the government decided that's how you would want it, I don't know. But my experience tells me that's not really how you want it. And so to reiterate a little bit about what was said about estate planning, please take part in estate planning and have a will that tells us how you want it to go. Because after 20 years, I've never seen anybody who really wanted it to go the way the state says it goes. So just to give you a quick overview about the probate process, because that's really what we are known for. Whenever you die, as I said, we want to get property that is in your name into somebody else's name. Now, that would seem like a rather obvious thing that people would want to do, but for some reason, it's not. And many people, whenever they pass away, nobody ever shows up in our office to transfer the property out of the decedent's name. And that leads to what? Heirs property. That's why we're really here, is because people don't come and participate in the probate process. Another thing that probably is in a small percentage, but I've actually encountered quite a few people who had a will, or their spouse had a will. When the spouse passed away, they did not come to probate because my spouse had a will. I already know what my spouse wanted to do. Unfortunately, titles to vehicles and titles to land are public record. They have to be transferred on the public record. And if you have a will at home in the top drawer and it stays there, the public record has no idea that your spouse has a will in the top drawer of the dresser saying where he wants his property to go. And so it has to be brought in. And unfortunately, a lot of people go to the, I won't say a lot, but there's a recognizable percentage who go to the trouble of getting a will. The person dies and they think, well, that's all I had to do. I got a will. No, you have to bring it in and go through the process. So the process, well, the process depends, of course, of whether or not you have a will. The first thing that has to be done in the probate process is you have to put somebody in charge. And that seems to be a point of contention for many people. Many people believe that the biblical law still applies. Now, I don't know why people believe that. Because from my viewpoint, America decided we weren't going to follow God's laws quite a few years ago, and we've went our own way for some time now. But they think, well, we're going to follow the biblical law, so the oldest child, or I should say, even though it's not politically correct, the oldest male child is in charge. But that is not our law. That is not the law we follow. The law is that there is a preference, first and foremost, to the spouse. And if the spouse is not qualified, then to one of the children. But it does not specify that it be the oldest child, and no preference is given to the oldest child, nor is any preference given to gender. So we don't follow the biblical oldest son rule any. The other thing that's important about that is whenever you do a will, you have the right and the opportunity to tell us who you trust and who you want to be in charge. And so if the will tells us who is to be in charge, then that's who we appoint. Now, that person may turn out to be untrustworthy, in which event there's a process to have them removed. But initially, they would be appointed just as a matter of law, because the will has said that I want this person to be in charge of my property. If we get somebody appointed, then their job is to figure out what the dead person owned, who it's supposed to go to, protect it for about 8 months, and then distribute it. Why 8 months? Because creditors of the decedent have 8 months to file a claim against the decedent's property. And so if you, as the personal representative, go to Bank of America and take the money and go give it to your sister, who the will says is supposed to get it, and then the creditor comes in and you say, well, I don't have any money, I already gave it to my sister. Guess who's responsible? The PR is responsible. So it's not a very good idea to distribute the property before the creditor period expires. Obviously, if there is a sole beneficiary and a sole personal representative are the same person, then it might not make any difference about the 8 months. But otherwise, we caution, and the law certainly instructs people not to do that. So that is the process to have someone put in charge to gather up the assets and then distribute them either according to the will or according to the state's will.
Thank you. My next question is, what are the toughest problems and or decisions you've handled in your courtroom?
When Ms. Bogan told me she was going to ask me that question, I thought, oh boy. I think the toughest does not really involve estates. I'm going to say it involves guardians and conservators. Many of you may know the Honorable Irv Condon, who's been the probate judge in Charleston County for many years, and at a seminar that he conducts every year, he made the remark that when he first became probate judge, people fought over mom and dad's assets when mom and dad died. Well, many things in our society have changed in the time that Judge Condon and I have had the privilege of being on the bench. And one of those changes is people are greedier than they ever been. And they're not going to wait for mom or dad to die to steal mom and dad's property. They're just not going to do it. They're too greedy. And so once mom or dad become mentally incompetent, that's when the thievery starts, and that's when the family falls all apart. And so the toughest cases don't involve estates because people have become so greedy they won't let us get to the estate before we start fighting. We're going to fight way before that. We're going to fight the moment mom and dad have some problem with their mental capacity. And for some reason, there's always one child, there's always that one who thinks mom and dad would want me to have this. Well, mom and dad are no longer able to tell us whether or not they would want you to have that. There's no written directive that says mom and dad would want you to have that. But you just know in your heart, the fine person that you are, that mom and dad would want you to have that. And so the toughest cases, without any doubt, involve dealing with siblings of incapacitated adults. The toughest case I've ever had, I'm not going to use anybody's name, and hopefully none of you will remember this, but I had a case involving a lady who was incapacitated. She had a daughter and a son. And the animosity between the daughter and the son was so great that they couldn't even agree on what mom's name was, much less anything else. And they fought over everything. And at some point in the case, I received a call from a lawyer, and he said, "Judge, do you listen to station so-and-so on the radio?" And I said, "No, sir. I try not to listen to anything." And he said, "Well, they just had a lady on there, and she said that you stole her mother's house and sold it for $400,000. And I said, "Is this a prank call? Are you kidding me?" And he said, "No, Judge." He said, "These people are talking about you on the radio like you are the scum of the earth." And I said, "Well, I hope people who listen have enough sense to know that I don't even know how to count to 400,000, so it's not me. I haven't done any of that." And he said, "Well, would you like me to contact the station director and inform them that they need to retract this, or you're going to bring some legal action?" And I said, "Well, I think that might be a good idea. I don't think it's good for public confidence for people to think that the judge is stealing houses and money." He called me back in less than 24 hours, and he said, "Judge," I said, "What?" He said, "They fired the guy before I even could call him. And do you want to just forget about it at this point?" And I said, "Sure. You can't put it back into toothpaste back into tube. So he's already said it. Might as well be happy if he's no longer there." But that's how contentious these cases become. We become the enemy. The guardians become the enemy. The lawyers become, everybody's the enemy, because these children are so determined to make sure they get more than the other. And in this case, the daughter had probably had a better relationship with mom. She probably had done more things for mom. And if you looked at it from an equitable viewpoint, maybe she should have got more than the boy would get. But why don't we wait until mom passes away and let the courts decide if she didn't have a will, or if she did have one, then let's follow it. But those are the absolute toughest cases. And the thing about them is broken families. Broken families. I can tell you that case lasted about 5 years. I thought I was going to lose all my hair before the case ended. It actually ended up, the case started in Charleston County. Judge Condon recused himself and sent it to Berkeley County. After about 2.5, 3 years, I recused myself because the contentiousness had gotten so great over such things as accusing me of stealing houses and selling, that I decided it might be best if I don't hear any further actions in this case. I recused myself. It went to Colleton County. At some point, things got so bad there that they recused themselves, and it ended up in Horry County. Fortunately for everybody, the lady died. And so this case lasted 5 to 6 years and went through 4 probate judges and numerous lawyers. The lady in that case, I can't remember all of them, but she had no less than 6 attorneys during the course of the case. Her brother never had an attorney. He just represented himself. And so you asked about the toughest cases. Those are the toughest.
And lastly, as far as my prepared questions, what do you see as the major issues and trends in the probate court?
Major issues with attorneys or trends?
Trends, yeah.
Issues or trends? We have a new trend, a very disturbing trend. When someone dies, what's your name, ma'am? Ruth. Let's say that Ruth's husband passes away. And Ruth walks into the probate court and she tells us, my husband passed away. And we say, well, Ruth, did your husband have any children? No, sir. Well, Ruth, you're the sole heir. Did your husband have a will? No, sir. Okay. Well, Ruth, do you have a death certificate? Yes, sir. She shows us a death certificate. And the death certificate says the man died and he was married, and the parents are listed their own, and the date of death, etc. It doesn't tell us whether he has any children or not. It just says he's married. And Ruth tells us he doesn't have any children. We are a process. We are not investigators. When you walk in, Ruth, and tell me that you have no children and your husband has had no children, I don't say, Ruth looks like a liar to me. Let's get an investigation done. Maybe we would like to do that, but we don't have an investigator even if we want to do that. We have to take Ruth at her word. Now, there are some safeguards, but those safeguards don't work particularly well, to be quite honest. There are a lot of reasons they don't work very well. And one of the things that I'm sure all of you are aware of, whether you think about it on a daily basis or ever or whatever, I don't know, but did y'all know that we are a very mobile society? I feel almost like I am out of step with society because I've pretty much lived in one spot my whole life. I did move from here to Columbia for 7 years to go to school. But as soon as I finished school, I came right on back here where I started. And that's just not the norm anymore in our society. We are a very mobile society. And one of the things that we find out is that before Ruth married her husband, he was married to somebody at a young age and had 3 children. And Ruth really doesn't have a relationship with those 3 children. Matter of fact, they called her the other woman that wrecked their father's marriage to their mom. They're not real fond of her. And they live in New York, Detroit, and California, and they don't have much to do with her or dad, and they don't know squat. And so when Ruth comes in and says he had no children, there's a good chance she's going to get away with that for a while. But eventually it would probably come out. We have a case pending in our court that was started 2 weeks ago that fits the description I just gave you, and the man died 10 years ago. So it took 10 years for one of his own children to figure out that Dad died 10 years ago, and we need to find out what happened to Dad's property. That's how things get when you have steps and you have people moving, etc. I can tell you that things are changing. And I don't know that I could tell you why this is transpiring. But I've had the privilege of being there 20 years. For 18 and a half of those 20 years, to the best of my knowledge, we had one person who came into court, lied about who she was, got somebody's property and hit the road and has never been seen since. Now, in that case, it really and truly wasn't that big of a deal. Everything he had probably was worth less than $1,000. And maybe she earned it or deserved it because she did take care of having him buried, etc. And nobody else did anything for him. One time, as far as I know, in 18 and a half years. In the last year and a half, we have had 4 people who came into the probate court in Berkeley County and said, I am, and he or she does not have. Point blank lies, and they weren't mistaken. They knew who the other people were. They not only knew who they were, they had been in touch with those other people. They flat out just lied. Now, fortunately, in those 4 cases, and of course, if this hadn't happened, I wouldn't be telling this story today because we wouldn't know we had those 4 cases. We would only know about 1. But fortunately, in 3 of the cases, somebody else came in a short period of time before everything was gone and said, hey, my dad died. I need to open an estate. What's his dad's name? When they tell us, we say, oh, he's got an estate open. His daughter opened an estate. He doesn't have a daughter. Well, there's a lady here that says she's his daughter. He says, that's my cousin. She's trying to steal my property. Turns out he was telling the truth. He lived in New York. But that happened in a relatively short period of time, so it got stopped before it got too far. Now, the 4th one, it got stopped before it got that far. But it's a good illustration of how people in our society have changed and how brazen the crooks have become. We had a gentleman who came in, his son had been murdered. And he said that his son was unmarried and had no children, and that the boy's mother was deceased, and that he was the sole surviving heir. And no, I just told that all wrong. Can I retract that? He told the truth. I forgot. He told the truth. He came in, he said, my son was unmarried, but he had a minor child. And the minor child is his only heir. And I want to handle the estate to take care of my grandson. And we explained to him that the minor child's mother would have priority to take care of the minor child's assets. And she could give him that right, but we could not let him do it automatically. And so we told him there's two processes here. We can give you this form that allows the baby's mother to let you do everything, or you can come in, file a summons and petition, and we'll have a hearing to see whether we should appoint her or you. He said, fine, give me the form. He walks out the door. The next day, he comes in, and he's sitting at the desk of a different clerk. And the clerk who had helped him the day before happened to recognize him, and she said, did he get the renunciation? And the clerk that was helping him said, what? And she said, he came in yesterday and I gave him a renunciation. Did he get it signed? She said, no, he told me that his son had no children, no wife, and I'm the sole heir. So the clerk comes to me and says, Judge, we got a problem. I said, we can fix this problem. So I had a deputy go pick him up, and we took away all of his paperwork so that he was not able to use it and go get money out of the bank accounts, etc., because he was only appointed for about 30 minutes before we had him picked up and brought back to court. And I let him go to jail to learn a few things about honesty and integrity, and then I let him pay a fine to help the county recoup some of its cost and having to deal with his foolishness. But I would say to you, trends, if it never happened or only happened once in 18 and a half years, and now it's happened 4 times in 18 months, there's a new trend. And part of that trend is we are having to look for some other way than trusting Ruth. We have trusted Ruth for all these years to come in and tell us the truth. But Ruth, we're not going to trust you anymore if we can help it. We're going to try to find some other way to make sure you're not telling us a story. So that's probably the biggest trend that we've seen recently.
Thank you. Marcus, is it okay for me to open up the floor?
Yes, ma'am.
Yes, sir.
Question relates to whether or not should the administrator or executor actually get a bond, be bonded in handling the execution of the estate. With families, most of them don't, but in your opinion as the probate judge, should this person, the executor or administrator, be bonded, or it's so casual they don't, or what?
That's a good question. First of all, if you have a will and your will says that my personal representative does not have to be bonded, then that is the way it is. If you don't have a will, then you must be bonded unless all of the beneficiaries sign a document saying we do not want the PR to have a bond. And so to your question, that decision first is made by the family before we get involved in that decision. Now, your question really is, as judge and what I've seen, what do I think? And I think that almost all personal representatives do the right thing. Almost. We don't have a lot of theft by personal representatives. And theft is what would be covered by the bond. I would say that if there's a history and you as a sibling knows that your sibling has a history of not being a trustworthy person, then don't agree to their appointment without bond. But as a general rule, in light of the statistical data, I would say that it's usually okay not to have a bond.
And this is done through the insurance company?
Yes, sir. Ruth's going to talk to me now.
My name's in the Bible, okay? If a family does a title search, which goes back 50 years, and they're showing you that to prove something, how do you look at that? How do you respect that as far as any relationship to the will, the title search?
Actually, we don't look at the title search. All we look at is the current deed. And so if the current deed says the property is in your name, then we accept that as being true and accurate. Obviously, if somebody wants to contest that, they could, but we don't look at title searches, and title searches are not brought to us as a part of the process. So we really don't have anything to do with the title search, other than being a place where title abstractors come to get information when they're doing a title search. That answer your question?
Good afternoon, sir. Cliff King. Question for you. So, as far as the probate process, is there a requirement other than the death certificate for the family members of the deceased to provide evidence to who they are to that deceased person, such as a birth certificate, marriage license?
No. There is no requirement of that. As I said, we take people at their word. We're looking at a little more than that now, although the law doesn't require us to do more. One of the things we've started doing is, in addition to the death certificate, we require that we see the obituary, because generally in an obituary it would identify, even if it doesn't name everybody, at least it identifies whether or not the person had brothers, sisters, children, or whatever.
If the will says that the PR is to be compensated for whatever they do in taking care of business, does the state of South Carolina say what that percentage is, or does the probate say what they get?
Yes, and no, like most laws. They are entitled to compensation at the rate of 5%. However, the court has the discretion to reduce or increase that.
And is there a reason why they would increase or decrease?
Yes, ma'am. Many estates, excuse me, many estates are so simple that they only require about 2 hours of your time, and you're not going to get 5% if somebody objects to it. You're just not going to get it. On the other hand, there are estates that are so complex that nobody would do the job at 5%. How much time do we have?
About 4 minutes.
Dealing with her question. We had the biggest case that I've ever had in Berkeley County. A man died. His estate was probated in Berkeley County. And there are a lot of reasons it was probated in Berkeley County, but let's just say primarily it was done in Berkeley County because Berkeley County was the only place that he owned property in South Carolina. He himself was not from South Carolina, never spent any time here. I don't even know if he knew he owned land in South Carolina. This gentleman was multi-millionaire. He was involved in more businesses than you could shake a stick at. And his estate was enormous, but it was also very complicated. It was also very contentious. In his will, he made 3 people his personal representative. He named his personal attorney, his personal banker, and his personal CPA. So when this case started, the first thing that came in front of me, other than the original documents to open the estate, was a petition to enlarge the fees of the personal representative. Because at 5% of a multi-million-dollar estate, they were not interested. Just as a sort of a summary, when they first filed it, I thought, you people are crazy. But then I learned they weren't crazy. There was just a lot of stuff I didn't know. All 3 persons gave up their careers. The lawyer, the banker, and the CPA all gave up their careers and became full-time personal representatives and spent most of the next 10 years in a courtroom being sued or either suing somebody else as the representative of the decedent in all of these business transactions that were involved. Not only did they do that, but this decedent was from New Jersey. Now, I don't know a lot about New Jersey. I have been there, but I don't know much about it. But I got the impression that there might be some corrupt people who live in New Jersey. And during the course of this case, it seems that these 3 men's lives were often endangered. And during the course of the case, it seems that some people thought if I didn't rule a certain way, maybe this judge needs to disappear and let's get a new one. And we'll hope we can persuade him a little easier than he is persuaded. This was one heck of a case. They got paid a lot more than 5%, and they earned every dollar of it. And in the beginning, when they asked me to enlarge it, I almost thought they had lost their minds. But I just didn't know enough about what was going to happen in the future. Yes, ma'am.
All right, any questions online?
There is one, I'll make sure I give them an opportunity.
All right, so it says, you mentioned a renunciation document. In a situation of in-estate death, is there one for the next of kin to complete if he or she is not interested in being the PR?
Yes, that is what it's for. Because if you had a will, you would normally have somebody designated in the will. Of course, that person could also refuse to do it. In fact, these three gentlemen I just described, at some point, I think all of them wish they would have signed a renunciation. But yes, there is a form for that.
Awesome, thank you.
You said that the spouse will get 50% if concerning the children. Would the spouse still get 50% if they was dedicated to solely to the children?
I'm not sure I understand the question.
Okay,
Is there a will or no will?
a will?
Okay, and what does the will say?
The children should get all.
Children get all.
Okay.
However, there is something in the law called elective share. And the spouse could file for an elective share, and she would be entitled to 1/3, even though the will said otherwise. Unless, in writing, she had given up her right to that 1/3. So when rich people get married, a lot of them get what's called a prenuptial agreement. And in that prenuptial agreement, it says, I give up my right of election. So in that case, they wouldn't have one.
Suppose that's the second wife.
Same thing. It doesn't matter. You get it when you get married.
She automatically get 50%.
Automatically get the elective share, not the 50%, the elective share, which is 1/3.
Okay. Okay.
And that can be rather tricky. Going back to her question about tough cases, one of the tough cases I had involved this issue, a man had what I call a trophy wife. She was 30 to 40 years younger than him. She was really good looking lady. And I would have been proud for her to walk down the street with me too. I can understand. I understand why he was proud to have this trophy wife. But as a part of the deal, he made some arrangements. He thought he was going to control her elective share. And he went to great lengths. In fact, he bought her $1 million insurance policy so she would be well taken care of and not need to interrupt his will, which left everything to his son. Lo and behold, I declare, people do the daggonest things. He died. She got the $1 million. She had a ring on that was just, something. But she wasn't happy. She was so saddened by the loss of her husband that she needed another 1/3 of his estate, because otherwise she was going to have a hard time getting by on that $1 million insurance. And it was really a sad case, because this gentleman was a savvy businessman, had a very successful business. He went to a business lawyer and did all of these things from a business standpoint to protect his son from her. And unfortunately, the business lawyer, I guess, didn't do any probate law, and he didn't know about the elective share, and he didn't cover that. And so unfortunately, she got a $1 million life insurance policy that was supposed to satisfy her interests in the business, but she also ended up with 1/3. Let me say, from a judge standpoint, oh gosh, I hated that decision, but I knew it was the right thing to do under the facts and the law. And that's what I'm elected to do, the right thing under the facts and the law, whether I like it or not. It's not, it's not my decision what I like or not. I will say, I'm sure I'm not the only person that had a role in this, but I was one of the persons who had a role in it. But after that, I began to complain to all the legislatures that I knew. And they did change the law a little bit. And now, if that case happened, the $1 million she got would count towards her third. So she wouldn't get the $1 million plus a third. So it would diminish it a little bit. So.
Well, thank you so much, Judge. That will
Thank y'all.
conclude the panel.
If you live in Berkeley County, I hope I don't see you. Otherwise, it was good to be with you.
All right, everyone. So we now have another break. We will return back at 2. You can go to the Wells Fargo room. We have snacks, a couple of boxes of apple spice also left if you would like to grab those. And again, I just want to remind you all that if you would like to sign up for Increasing Hope, this information is to your left on the table to sign up to give that information to Miss Bernique. As well as with Hoover, thank you for those who have been downloading pictures. I've helped a couple of people, so again, if you need me to help you, let me know. Thank you.